I'd like to call the August 7th, 2025 Board of Zoning Appeals meeting to order. Everyone will stand for the invocation and pledge of allegiance.
Dear Heavenly Father, we thank you for this time that we could come together and represent our city in making these decisions in the best interest of our city. Help us to give us the strength to make the right decisions. In your name we pray. Amen.
Next, we'll have the roll call.
Sarah Majeski here.
Sylvia Carnes.
Terry Hayes.
We're doing roll call.
I think yours is down here. I didn't see it. It may be slid down to the side. Right there. Let's see. Nope. Oh, that's me. Look right here. Here I am. There you are. That's okay.
Thank you. Sorry about that.
We just had roll call if you just want
Oh, Candace Gerald.
to.
Okay, we need to approve the May 1st, 2025 regular meeting minutes. Motion to approve.
I'll make a motion to approve.
Second.
Cast your votes.
Are we doing the lights?
Are we doing the lights? No, go ahead.
There are no organizational or procedural items, no unfinished business. On to new business.
Good evening. I hope you all are doing well, and glad to see you all back here since our last meeting in May. New businesses is an appeal of denial to place a manufactured home at 213 Railroad Avenue, in particular Lot 12. And you see in your package, I've marked in there the approximate location of Lot 12. The request, the applicant is appealing against the decision of the Planning and Community Department to deny the permit to place a manufactured home at 213 Railroad Avenue, Lot 12, in accordance with Section 6.070. Subject property description. The subject parcel is located at 213 Railroad Avenue. The parcel number is G11035. The subject property is plus or minus 3.4 acres and has approximately 162 feet of road frontage along a private road known as Hatton Lane. The subject property is currently zoned RC1, residential. Lot 12 is surrounded by parcels zoned as RC1 to all sides. Findings of the fact, the appellant owner, I.E. Wang, Ever Domain Mobile Home Estate, LLC, per the City of Grovetown Zoning Ordinance, Appendix A to the Code of Ordinance, manufactured homes are not permitted in RC1 residential if the property has been vacant for more than 1 year. And you have the applicable zoning codes in the packet. I'm not going to read every single item in there because it is quite lengthy. And it was properly advertised in the legal organ for the required amount of time before this hearing took place. And that's all I have right now.
like to open up the comments.
Do you do public comments first before the applicant speaks?
First you,
First me?
and then the
That's what I figured.
citizens.
All right. Thank you so much. I'd say ladies and gentlemen, but ladies. Thank you so much, ladies, for having me. My name is Jeffrey Peel. I'm the attorney for Ever Domain Mobile Estate, the applicant for the new mobile home on Lot 12. I have 3 witnesses today that I'd like to call. I think I'll be relatively brief, but I just wanted to make a quick opening statement regarding, why we decided to appeal the denial of the permit. So I'm sure y'all have very, very competent counsel, and I can see that sitting to the left of me here. But they've probably made y'all aware of state statute. And the specific code section is section 36-66-7. And that statute was enacted relatively recently. It was 2023. And it was designed based upon the comments to kind of clarify all of this mishmash of law that was happening. Because there was lots of different cases and things like that where mobile home owners were bringing claims and saying, this is a taking. I have a viable non-conforming use. We understand that a city like Grovetown may want to get rid of certain mobile homes. They want to expand it into R1, single-family residence, that kind of thing. And the General Assembly stepped in and they said, notwithstanding any other provision in this chapter, when there is a replacement of a pre-existing manufactured home or a mobile home with a new home within a manufactured home community or on any other residential land, a local government shall not adopt or enforce any zoning decision or zoning ordinance or any other regulation or restriction or impose any conditions on the new home, the property upon which it sits, the owner's property, blah, 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 that had not existed before. And there are some exceptions written into that code. And one of those exceptions, and that's the one that I believe the city is relying upon in their denial, is subsection C2, which says that the nonconforming use has been discontinued for the period of time established by ordinance, which shall not be less than 12 months, unless such discontinuance is caused by circumstances outside the control of the property owner. And I think it's always kind of boring for a lawyer to stand up here and read a statute. I just wanted to make sure I had that out there because this is the framework under which this appeal was brought. Essentially, in this particular case, this mobile estate, whatever you want to call it, that currently exists in Grovetown has multiple mobile homes, and it has for years. We've traced the deeds back. We have the exhibits here. This has continued as a mobile home park on this parcel for its entire existence. And what the owner, Mr. Wang, wants to do now is simply place a mobile home on a lot that has been sitting vacant. And it may have been sitting vacant for more than 12 months. He's not aware. But there's a few important facts that I think will come through today. Number one, at no point did any of the previous owners, including Mr. Wang, ever discontinue the period of use. It does not say in this statute if a lot sits empty. That's not discontinuing use. It's undisputed. This entire area has been a mobile home park. This entire parcel has been a mobile home park the entire time. And so at no point did any of the owners of this particular parcel say, we are not going to be a mobile home park. Totally different case if he built a liquor store there or built a service station or a convenience store and then wanted a mobile home a few years later. This has been a mobile home park the entire time it's been here. So he did not discontinue. No owner has ever discontinued use. The second point that I think will come through with the testimony that we have today is any discontinuance in use was caused by circumstances outside the control of the property owner. This particular mobile home park, the way that it operates, is it allows people to purchase their own mobile homes and park them on the lot. They simply rent out the spaces. That's what they've done going all the way back. And so they can't control who buys a mobile home and parks it for sale in their property. And they certainly can't do that within a 12-month period. In this particular case, it has been consistently advertised for 2 decades that there are lots available for rent. Bring your mobile home and do it. This permit application arose when, after a long period of time where there were no applicants, an applicant came, and now they have a need to use their lot because someone wants to bring their mobile home on the property. So that's basically my entire opening statement. It's that simple. I believe that the ordinance that's being enforced violates the statute as it applies to my particular client in this case. So at this time, I'd like to have Mr. Hei, he goes by Andy Wang, step up to the podium, and I'd just like to ask him a few questions, if that's all right. All right, thank you. Could you introduce yourself, please, sir?
Hi, everyone. Well, my name is, legal name is He Wang, but I do go by Andy, so. And nice meeting everyone here.
And are you one of the owners of Ever Domain Mobile Home Park?
Yes, I'm the sole owner of Ever Domain Mobile Estate LLC.
Okay, so that LLC is a single-member LLC. You're
Correct.
the sole owner of it. And when did you acquire the property in the city of Grovetown, and you being Ever Domain Mobile Estate?
This specific mobile home park was acquired on April 17th, 2025, which is this year.
All right, and we have a bunch of exhibits, but I'm going to show you Exhibit 10, and I'm going to represent to you that this is a certified copy of a deed to the property. And it's dated, as you indicated, April 17th, 2025. Is this the deed that you accepted for the property?
Yes,
All right. Now, I understand that shortly after you acquired the property, you began inquiring with the city of Grovetown what you could do with the empty lots. Is that correct?
correct. I had email communications with the Department of Permit and Zoning, as well as the director, Mr. Jack Palmer.
All right. And what was the nature of the emails? What were you trying to accomplish?
Well, in the email, I basically searched up existing cases, which are very similar to the one we are encountering right now. And I have inquired if we are allowed to put like new mobile homes on this lot, in which Mr. Palmer and I guess the staff of the Planning and Zoning Department has replied that due to the ordinance of City of Grovetown, we are not allowed to place a new mobile home.
All right. And you made these inquiries before you purchased the property?
Correct.
Is that correct?
Yeah.
All right. And then after you purchased the property, you went ahead and applied for a permit to erect a mobile home on Lot 12. Is that correct?
Correct.
All right. And I'm going to show you Exhibit 13. Is that right? Excuse me, Exhibit 12. I'm pointing you to what's been identified as Exhibit 12. Is that your signature on that document?
Yes.
All right, and this is dated June 20th of 2025. This was your application for a manufactured home permit, is that correct?
Correct, for Lot 12.
All right, now, to the best of your knowledge, is that a vacant lot?
Yes.
All right, what do you know about the lot? Is there plumbing to the lot?
Well, there are plumbing and sewer like hookups to the lot, which has been stayed vacant for many years.
Okay, and to the best of your knowledge, has that lot been used for anything other than a potential mobile home site since you purchased the property?
No,
All right, is there anything on it currently?
no,
And I say anything, I mean, except for like the plumbing fixtures, the sewer fixtures, those kind of things.
no.
And is there a hookup for electrical?
I believe so, but yeah.
Okay. All right, and so is it your intention, if ultimately successful, to have a mobile home placed on the lot?
Yes.
After you purchased the property, did you notice, were there any advertisements for applicants to obtain or to rent from your company?
We have posted up signages at the front of our property for interested applicants to contact us, in which we have received a few, but like interested inquiries.
All right, were there any that qualified from those applicants?
No,
No, so you haven't had, you've received applications, but you haven't received any qualified applications?
Correct.
Is that correct? All right, do you know, was there any existing signage about spaces for lease when you acquired the property?
no,
So you don't know?
To the best of my knowledge, I'm not aware.
Okay.
Yeah.
All right, I just want to make sure that the answer is clear. All right, 1 second. All right. I have no further questions, actually, for Mr. Lang.
You want,
me go ahead and question him now, or do you want me to call him during my case and question him?
I'm not familiar with this process. If you
I
want to
think
question
it'll
him
be
now.
flexible if you and I will do it, that way we don't have to call him again, is that okay?
yeah.
Thank you. Mr. Wang, I'm just gonna stand right here, I can talk loudly. My name is Scott Kelly, we've never met before, I represent the city. I just have a very few questions for you. To stay on the subject you're on just for a moment, I thought I heard you tell the board that people bring their mobile homes to the property and you just rent the pad, is that right?
Correct.
But you sought a permit for a specific mobile home that was introduced in evidence. You were gonna bring a mobile home there and then find a tenant for it, correct?
It could be done both ways, correct?
Okay, just wanted to clear that up. And just to understand, you purchased, Everdomain purchased the property effective April 17th, 2025. That's about 3 months ago, correct?
Correct.
And the deed is in the record showing that you purchased it from a company with it's another corporate entity or LLC called Lockwood, correct?
Correct.
Before you purchased the property, you did due diligence, didn't you, sir?
Yes, we did.
And one of the things you did is you learned, as you've already indicated, that this lot, Lot 12, was vacant.
Correct.
And you also, obviously, as you indicated, you know that it had been vacant for, your words, many years, correct?
Correct.
You contacted the city, well, first of all, your broker contacted the city, and then you contacted the city about whether you would be allowed to get a permit to put a mobile home on this vacant lot, correct?
Correct.
And you communicated with Mr. Palmer, who's the director of the Department of Planning and Community Development here at the city, didn't you?
That is correct.
And Mr. Palmer explained to you, and in writing, maybe also verbally, I don't know, but in writing certainly, that you would not be permitted because that had been abandoned since it had been many years and no mobile home had been put back on the lot, correct?
Correct. May I add something here?
You may certainly add something.
Yeah, Mr. Scott?
Yes, got it.
Okay, so sorry about that. Yes, while everything we just talked about is certainly 100% correct, I did want to mention that the topic that we're discussing today, I think is more relevant to the contradiction that we have in regards to the City of Grovetown's ordinance with the state statute. So,
And I appreciate that you and I might not see this the same way. That's why Mr. Peel's here for you. And there are legal questions that I'm sure that might come into play, as Mr. Peel's already alluded. I'm interested in understanding the facts as you know them, and I think you've cleared most of those up for me. But again, the bottom line is, you knew before you purchased the property that a mobile home had not been there and would not be allowed there, correct?
that is correct. We bought the property and seek those value-add opportunities.
Right.
Yep.
And in fact, you paid $675,000 for the property.
650,000 actually.
Well, I'm looking here at the limited warranty deed. Do you see that transfer tax of $675?
That's correct. Sorry, I was misunderstanding.
That's
Yeah.
okay. It's 1% of the sales price. That's how I know how much you paid for it. And it's okay. That's a
Yeah,
not a big
that's-
difference. But you clearly thought the property had value even without lot number 12 being used, didn't you?
Well, part of the purchase price also includes the presumption that we are able to place new mobile homes onto existing lot in which we could increase the value of the whole property. So that's just sort of like the rule of the mobile home park
Is
input.
it your testimony, and I understand that you're hoping to be able to win this, but is it your testimony that if you can't use lot number 12, that the property loses all its value?
Well, certainly not all of its value, but it does have major impact on its resale value in the future.
What would you have paid for it if you off the value of the property?
The purchase price we paid was inclusive of everything we know to the best of our knowledge while we performed the due diligence. So it would be very hard to give a very specific number as to what the value of this losing pad was, just because it's very market dependent, as well as depends on the interest rate and the current rent at the time that we resell the property. So I'm unable to answer this question.
Well, let's just be reasonable people. How many lots are there out there?
It has a maximum 23 pad.
23 pads. If you divided 23 into 675, wouldn't that be a good way to estimate the value for each one of those lots for you? Don't you think that'd be a pretty reasonable way to do it?
Well, again, the value of the mobile home park property was closely tied to its income stream. So this is, again, like, I mean, we could say that that could be the value that's reflected at the time of purchase, but assuming we would be able to raise rent, build back a utility, and do other like measurements in this way, this value might not be 100% accurate. Yeah.
But it is your testimony that you thought it was worth $675,000, knowing you might not win the case.
I agree with the first part. Well, the second part, I would just say this might not be like very relevant, but it is very common that we like, I guess, also calculate the value of the vacant pad while we purchase it, just because we anticipate that we'll be able to place mobile homes like onto those existing pad as part of our value add strategies. So.
One last brief couple of questions. Everton May Mobile Homes is a limited liability company, correct?
Correct.
And are you the sole member?
Correct.
Okay, so you are the sole member of Everton Maine, and you were able to purchase this property at the price we discussed, correct?
Correct.
No further questions.
Thank you.
All right, and I don't know how we want to do this for the record, but council and I kind of went through, we have a lot of exhibits, most of which was produced to us by the city of Grovetown. I think we just stipulated we're going to admit all the exhibits.
Yeah, and I'm fine if you just state, you know, you probably have yours labeled plaintiffs. I have mine labeled city one, and I have a much fewer list of exhibits because there were some things that were duplicative. So we didn't want to provide you with 2 copies of the code or 2 copies. So for the most part, I think we have to all be pretty cooperative in getting this before you so that you won't see a lot of fuss over it.
All right, and I don't know what the best way to do that is. I mean, obviously, we have a court reporter here. Give it to
I
her.
think we ought to do them one by one, only for the record, if the court has to look at this later. I did see that some of them may be missing from my stack, so I just want to make sure that I make a note of that, and they may be just out of order if they were going to do so.
All right, I mean, I'll do it.
It may be a little dull, but,
We'll do it one by one. Excuse me, this will be probably fairly boring. But the Exhibit 1 that we have to tender is the original zoning ordinance from the city of Grovetown from 12/20/1976, and it is certified by the clerk. So I would admit this at this time. Exhibit 2 is the original zoning ordinance from 1976. I'm not sure what's... Okay, that makes sense. So the first exhibit is what has been codified, and this is the uncodified version that must have been used for planning or something that was given to us by the city of Grovetown. Again, it's certified. The third exhibit is the zoning ordinance from May 12th of 2014. So it looks like the city of Grovetown didn't make any zoning ordinance changes for about 40, 50 years there. So that's exhibit.
if we can let the record reflect, that's the city center. The board will be familiar with this. That's
Yeah.
no longer existing.
City center districts.
Right.
Yes.
All right. Exhibit 4 is the current zoning ordinance from May 8th of 2023 that went into effect. All right. Exhibits 5 through, okay, there's 2 pictures each. Okay, 5 and 6 are 2 photographs I'm going to set these aside for right now because the next witness is going to explain what these are, and I think that would make it a little bit easier. Exhibit 7, this is the letter that was sent by the applicant, well, actually by me on behalf of the applicant, appealing the decision of the denial, and explains our reasoning. Exhibits 8, 9, and 10 are the deeds in the chain of title going back to February 15th of 1994. We've already discussed Exhibit 10. Exhibit 8 was the deed between Stephen Brown and the Colemans. Exhibit 9 is the deed from the Colemans to Lockwood Investment, and Exhibit 10 is the deed from Lockwood Investment to Everdomain, the current owner. Exhibit 11 is the city's response to an Open Records Act request we sent prior to this hearing so that we could get all this stuff lined up for y'all. Exhibit 12, we just discussed. Exhibit 12 is the actual application that was made to the city by Mr. Wayne. Exhibit 13, yep, is an email from Joanne Murdoch at Planning and Development for an application for a business license. Exhibit 14 is an email from Grovetown regarding a business license for Lockwood. Did we skip down? Yeah, there's two 14s. That makes sense. Okay, let me correct. This is an application by Lockwood for utility services, the prior owner. All right. Exhibit 15 is a notice regarding the business license application by Mark Coleman. Exhibit 16 is a building permit application for Lot 3 by a Jonathan Newman. Exhibit 17 is a self-work affidavit for Lot 3 by the same Jonathan Newman. Exhibit 18 is the building permit application for Lot 18 by Emmanuel Escobedo. Exhibit 19 is the inspection report for Lot 18, which had sustained some damage. I don't see 19 up here. I think we skipped 19, but 19, okay, we did 19. All right, excuse me. All right, Exhibit 20 is some receipts for the Lot 18 building permits. Exhibit 21 is a building permit application for Lot 1 to Lisa McMahon. Exhibit 22 is a self-work affidavit regarding storm damage for Lot 1 by Lisa McMahon. Exhibit 23 is a building permit application for Lot 24 to Anderson Mechanical. Exhibit 24 is renovation permits for Lot 17 and Lot 10. Exhibit 25 is ordinance 195 regulating the age of mobile homes. I note it's not signed, but this was produced by the Open Records Act. Okay. Number 26 is ordinance 198 regulating permits for mobile homes. Exhibit 27 is ordinance 226 regarding losses of non-conforming uses. Exhibit 28 is ordinance 232 amending provisions involving nonconformities. Exhibit 29 is ordinance 122 relating to signs and advertising. Exhibit 30 is ordinance 2020-10-02 revising provisions relating to nonconformities. Exhibit 31 is ordinance 2023-04-03 amending and restating the comprehensive zoning ordinance.
Jeff, just real quick, just exhibits, we've just gone through, beginning with Exhibit 11 through Exhibit 31, were all documents produced in response to the open records request that Mr. Peel sent for his colleague there.
Correct.
And so 11 begins, these are the documents, and 11 through 31 are the documents that were sent.
That's correct. And actually, I believe, did we do Exhibit 32 was as well?
Was his occupational
Yeah,
tax also?
and I think you guys produced this to us as well. So Exhibit 32 is the occupational tax certificate.
We're willing to stipulate then that 11 is the letter, and then 12 through 32 are the documents produced by the city in response to their open records.
And then we did kind of a bulk exhibit, Exhibit 33, with a bunch of emails that flew around between my client, various people from the city of Grovetown, all relating to this. So it's just kind of a collective exhibit, Exhibit 33. All right. So we got that out of the way, and I think I reserved 2 exhibits there. Right. So at this time, then, I would just like to call Mr. Chris Lopez. Could you state your name, please?
Christopher Lopez,
And Mr. Lopez, where do you live, sir?
213 Railroad Avenue, Lot 17,
And how long have you lived at Lot 17?
about 12 years.
About 12 years, so would you say that it was, you've lived there since 2013?
Yes, sir.
Okay, and what is it you do for work?
I do railroad work full-time, and then I take care of the park on my time off. I cut the grass, read the water meters, clean the park, everything.
All right, and just to be clear then, so do you work for Everdomain?
No,
No? Okay, when you say you do this work for the park, what do you, who pays you for that work?
that takes off the rent.
That takes off the rent?
Yes.
Okay, so it's not a situation where they hand you cash
No.
while you get there. Did you have a similar agreement with the previous owner?
Yep,
of the property?
all 3 of them.
All 3?
Mark Coleman, Andy Lockwood, or David, whatever his name was, and then Mr. Andy.
All right, so from 2012 until now then, you've had this arrangement basically with the owners of the park?
Yes, I have.
And just to be clear, there's been 3 owners.
Yep.
The first one was the Colemans?
Yep.
And then,
Dan Underwood, and then Andy.
okay, and then you had Lockwood,
Yeah, that's a Dan Underwood.
that's the Dan Underwood, okay, and then Andy. All right, I just want to make sure. All right, I want to show you what I have marked here as exhibits 5 and 6. Yeah, all right. Let me make sure I got them in order. 5 and 6. What are we looking at in these pictures?
This picture right here,
Okay, and for the record, you're holding exhibit 6?
6. It's got the water meter and the sewer.
Okay, and you say
That's a
water,
working water meter too.
water meter in the sewer, is that on lot 12?
Yes, sir.
Okay, now let's turn to exhibit 5. What are we looking
Exhibit
at?
5, if you look, that's a gas line. They come out and took the meter off. If you block, right there's a water pipe. That, cut the valve on, it'll shoot water out. The gray pipe right there is a power line.
So, having lived there for 12, 13 years, do you know about how long this lot has sat vacant?
Maybe 6 years due to a tree falling on the trailer. That's the only reason why that trailer is not there.
Okay, and explain about that. So, do you know who the previous owner was of that unit?
John Meyer.
John Meyer. And, I mean, were
Well,
you?
not John, Ashley Whitlock. She owned the trailer.
She, okay, were they friends?
Yes.
Okay. But John Meyer lived there with
Yep.
Ashley, is that it? All right, and, I mean, you were familiar with them?
Yeah, that's my brother-in-law and my sister-in-law. So, yeah.
Okay. All right, so the tree fell on the trailer. What did they decide to do?
They tore it down.
They tore it down, they moved someplace else?
Yeah.
Okay. So in the 6 years then, is it fair to say 6 years that that lot's been vacant? Have you seen any of the owners of the lot use it for any purpose other than trying to rent it out for mobile
No, it ain't been used for nothing.
Okay, and in the 12 years that you have been there, have the previous owners also advertised lots for rent within the park?
As far as I know, yes.
And how, when you say far as you know, how do you know?
They said that it was up for rent if we could find somebody to put a trailer on there.
Was there ever any signage posted?
I know it was, I think it was online.
Okay.
I think that's how they done everything online.
All right, did you ever see any of those
No.
postings or anything like that?
I don't get online, so.
Okay. But,
Some help, if I may add. I believe that posting is still up on sale right now.
okay,
Last about 5 years.
all right, so, I mean, basically, the previous owners of the lot told you that it was for sale.
Yeah,
Right.
for rent. Yeah.
For rent, that kind of thing. All right, now, how many units are in the total lot, to the best of your knowledge?
It was 23.
Okay, and that's just 23 pads,
Yes.
basically, is that correct? Do you know how many mobile homes there are on those 23 pads?
If I'm right, Chip, he's on 2 lots, so 22 trailers without, well, he probably.
Is this the only empty lot, or are there some other empty lots out
Well, there's one empty because of the hurricane.
there? Okay, and so that happened more recently?
Yes.
Okay,
So this was the only empty lot.
all right. Let me ask you this. Was there ever an indication by the previous owners or the current owners that they wanted to use this park for anything other than a mobile home park?
No. It was always told by me that they were just gonna leave it at a mobile park.
All right, 1 second, if you don't mind. All right. Doing my best to not keep us here too late. I got a 5-month-old at home, and my wife has been watching him all day, so I'm gonna be brief. I'm done. That's all I had. Hey, and obviously, he may have some questions for you.
Don't, not so fast. What's your name again?
Chris Lopez.
Hey, Chris. I'm Mr. Kelly, Scott Kelly. My kids call me Dad. I bet yours does too. So, just to be clear, you've been there a while. When Mark owned it,
Mm-hmm.
that's when the tree fell.
Yes, sir.
And the trailer was taken away. It was owned by Miss Whitlock.
Yep.
And no new trailer was put there by Mr. Coleman.
No.
He continued to own it for a few years, right?
Yep.
And then Lockwood bought the property. Tell me, do you own your trailer, or do you rent the pad and the trailer from him?
No, I own my trailer.
Okay, so you just pay for the pad? You hook it up, okay. Did you then pay rent to Lockwood for about a year?
No,
Did you let you stay there for free?
no, I worked for it.
You bartered, so your work paid for your pad?
Yeah.
Fair enough. You paid for it
Yeah.
just with your sweat
Yeah.
rather than, okay. But during that time, when Lockwood owned it, and they were collecting rent from all your neighbors, either for the pad or for the trailer and the pad, they didn't replace anything on that vacant lot, did they?
No. Cause they supposedly from Sabrina, which is his secretary, said that it was online.
Well, probably not a good idea to talk about what other people
Yeah.
said. If they're here, it's great,
Yeah.
but I don't want
That's
to do
hearsay.
what we call it. That's right.
Yeah.
You got it. It's not reliable. So, the bottom line is, that property, that pad was vacant when Mr. Coleman had it, when the tree fell on it. He never replaced it. It was vacant the entire time Lockwood had it, and Mr. Wang bought it, and it was vacant then, and it's still vacant today. Years have gone by, right?
I mean, what do you consider vacant?
Vacant meaning there's not a mobile home on that lot.
But I mean, it's still got water and power and all that, so it's still
They're not
usable.
hooked up. Vacant means, when I'm using it, there's not been let's be clear, there's not been a mobile home there for years, right?
Yeah.
And there's not been a mobile home since Mark Coleman owned it and the tree fell on it and one was moved away. He never replaced it, correct?
Right.
Okay. Look, I appreciate your testimony. Thanks. Not really a testimony, nobody's taking a note, but there you go. It's there.
Just so I'm clear for the record then, exhibits 5 and 6. Okay.
We agree there are hookups still out there.
All right. So I think that's my entire list. My last witness has informed me he wants to make a comment as a member of the public. So there is,
When you're
yeah.
done, then they do that, and then we'll go.
Yeah, and so,
So he wants to do it as a comment?
Yeah,
not
a
as
comment.
Witness.
yeah, not necessarily as a witness, so
Okay.
those are the 2 witnesses that I have. And that's it. I don't have any further witnesses.
Madam Chair, as a point of order, now that the applicant has concluded his presentation, you can add, if you recognize any of the board members, they can ask questions of the appellant.
Okay. Anyone have questions?
I'm just curious how much lot rent is.
That's a fair question. Oh, you need to come to the mic.
Currently, the lot rent was $350
Per month, correct?
per month, yes.
$360?
$350. No.
I have a question. How does Georgia code supersede Grovetown's ordinance?
Well, if you're asking me, I'll be happy to address it during my presentation.
Okay.
I certainly want to let the way, as I understand the procedure, and I want to follow y'all's procedure.
Right.
Mr. Peel finishes his case, he's done. Public is, including this gentleman in the back, if they want to make comments, whatever they do. And then I believe it's our turn, and we'll be brief, but I will also address the legal issues, just like I assume Mr. Peel might want to now.
Okay.
Yeah, I mean, I was just waiting if there were any more questions.
Ladies? No? All right. Open, you guys can go ahead.
Oh, question. Do we get to look at the exhibits?
Yes, ma'am.
When do we get to do that? And do we get to ask questions about those?
Do that now.
I'm just not sure how this,
Yeah.
yeah. I don't have all my questions because I haven't seen all the stuff yet.
All right, I mean, is it all right if I just tender them up there?
You all are the boss. This is an administrative hearing. We'll do it how you want. I can tell you that frequently in these kinds of matters, we'll present the evidence. We'll give you an opportunity if you want to ask Jeff or me a question.
Okay.
But then you all would recess, you convene
Okay.
privately and make your decision. We don't come back. I mean, we'll give you everything.
Okay.
You can examine it, but it's our job to present the things that we think are most relevant
Okay.
to you, but it will be in the
Present.
documents and whatnot.
We'll let citizens talk and them talk and then look at
Yeah, I
everything
agree
and
with
then
that.
come up with questions.
That's
Okay.
fair.
Perfect.
Okay.
Thank you.
Should I? Yeah, is it all right if I just?
Yeah.
come on?
Go right ahead.
These are all the exhibits.
Thank you. So.
All right, I'm going to close staff comments and open it for the public.
Read your
Mr.
first
Bergeron?
Good evening. My name's Charlie Barger. Thanks for hearing me. I'm going to try to be as brief as possible because I know, oh my God. I am here because I wanted to give you a little bit of context. I'm actually in a unique position here. I've been a tenant of the park for 13 years. And when I moved there, Mark and Susan had it. Now, at that point, you could rent or own. It was later on that they gave everybody an opportunity to buy the trailer that they were in if they wanted to. And I've purchased 2 out there that way. The first one we lived in and the one we live in now. I don't know if many of you remember, there's been a lot in the history of this town, but a few years back, there was an effort to zone us out of existence, which led to a big meeting here in this very room, which I know Miss Majeski was there. I don't know if any of the rest of you, which we had a big fight about that. We wound up winning. Then the next step was they wouldn't let us work on our homes and hadn't let us work on our homes for years, which led to another big fight in here that I led, which led to the last form-based code committee from the citizens. So I've been in here talking a lot about this trailer park. And when we got through all that, okay, it was about 6 years ago, I think, that a storm dropped a tree on the trailer in Lot 12 that they're talking about, where Chris's brother-in-law used to live. It took a little while to get it cleared out because they had to do it safely with the gas hookups and everything. But from that point forward, Mark and Susan were trying to replace it. I should know she came to me and my wife for help because at one point my wife was the chairperson of the Planning and Zoning Committee. So she would come to us and ask us questions about what she needed to do and how she needed to do it. She started off, they were going to put one in there themselves. And at the time, they were going through ordinance changes. You may remember after Scott and what was his name, the other city administrator got out of there, Ronnie started going through, looking at everything, changing it. So every time she would go to ask questions, it'd be like, well, this is up in the air now, okay? This lasted for years. She had no fewer than 5 people that were interested in putting a mobile home there. And all 5 of them, after they came down and met with whoever was there in the office, suddenly thought it was too much trouble. Now, I'm not trying to cast aspersions on anybody here. Nobody that's sitting in this room here was there, well, except for him. But she actually came to us, and again, she was going to try to put a trailer in there. And then they decided to sell, okay, to Mr. Underwood, who did intend to put a trailer in that empty lot. Now, with all due respect, I'm not going to just put that out there. I'm pretty sure I've got either an email or text message, because I talked to him, where he states as such. But Mr. Underwood took over in August of last year. And if you remember, in September, we had a problem. A hurricane came in and destroyed our park. I think there were 2 or 3 homes in there that were seriously damaged. 2 of them are going to have to be pulled out, which, again, it seems funny to me. They're going to let them put new homes there, but they want to fight them to put the home in the spot that somebody's been trying to put a home in for 6 years. And I know $675,000 divided by 30, off the top of my head, that's a little less than $30,000. I understand that might not be much to you, sir, but $30,000 of value is quite a bit. Now, we have been in a struggle. We worried, all of us, about whether or not we were going to exist. When they sold to Underwood, we were worried, and we were given assurances. Then Underwood sold to Mr. Wang. And I got to tell you, out of everybody, Mr. Wang has come around, and he has assured us that we're secure. He's trying to make improvements to the park. He's willing to partner with us to help us fix up our stuff. And while that may not have any legal precedence here, this is what Grovetown's been saying they wanted the whole time I've lived here, for the park to be improved so it won't be an eyesore. And you have a guy here that's willing to work with us and do it. And all he's asking is you let him put a trailer where a trailer had been for 40 years before that storm hit it. And yet the city has gone to hiring a lawyer over one spot. One spot. You know, I know that emotions are not supposed to be a part of this, but when you go from our point of view, you know, if something were to happen, there's a lot of old people, families, we're going to be out of a way to live. They made an investment, and they're trying to make the most of their investment. And yeah, I'm here trying to help them, because they're trying to help us. They want to make our city look better, and they want to give us affordable places to live. How many times have you heard that talked about in this chamber? Who's doing it? Right now, the only one I know is that man. So, you know, consider what you want. But as far as the legal precedent, it hasn't been abandoned. That was a cute word. Nobody abandoned anything. Somebody has been trying to put a mobile home on that lot since it was tore down. And they've been getting pushback, just like they're getting pushback now. So if that factors in your decision, you know, consider that. I appreciate you hearing me out. I won't take up any more of your time.
Okay. Any other comments?
The stack. Did you get a stack of papers? Was he the only one? Comment stack. Right here. Okay, to your right. There you go.
Yeah, everybody spoke.
That was it? Okay. Next is,
Okay. We'll close the comments.
yeah, that's all. Yeah, you close the comments now.
No comments from online?
No, there's no online comments. No, we don't do online comments. Nope, that's it. Close the general comments. Yep.
Okay.
Now we look at this. Okay. Here we go. Right? Do you?
The attorney.
Would you like to
the-
speak
His
next?
attorney.
When the attorney present our case, I just wait and find out if Mr. Peel's done. You done?
Yeah, I'm done with mine.
Yeah, he gets to present his
Let me do
case
this.
now, the city's case.
When I went through and read the procedure, my understanding is they give their witness evidence, whatever, and then there's final kind of argument, and then we're done, so.
If we want to do it that way, I'm fine. I'm waiting for direction from them. Candidly, we'll do it
I would like to
however
ask
you
the
want.
question to council.
Yes, ma'am.
How does Georgia code supersede Grovetown's ordinance in this case?
Okay, and that was maybe me being boring at the beginning of the presentation, reading a statute. So in 2023, the General Assembly passed legislation, and they said local municipalities cannot regulate in this area when it comes to mobile homes. But they carved out some exceptions. So it's one sentence of the exception in the code that I believe Georgia is relying upon, or, Grovetown is relying on. Let me pull it up here. In this, when we filed the appeal, I laid it all out. I put the argument there, in a 2-3-page letter that I submitted with it. But, that provision that I read says that Georgia law says that when it comes to replacement of pre-existing mobile homes, municipalities cannot regulate this area, except, and they list like a few different things. Discontinuance is necessary for the safety of life or property. That's one. I don't think that's what the city's relying on. I could be mistaken. I haven't heard his presentation. What was stated in an email to us is this second exception is what's being relied upon. The non-conforming use has been discontinued for the period of time established by the ordinance, which shall not be less than 12 months, unless such discontinuance is caused by circumstances outside the control of the property owner. So our basic argument here is this. The General Assembly said you can't regulate in this area, and you can't pass an ordinance that says you can't replace this unless you can show that the non-conforming use has been discontinued for a period of not less than 12 months. I don't think they can show that. Remember, we might be talking about 23 different, mobile home lots here, but we're actually talking about 3 parcels with multiple mobile homes on each parcel. Every single one of those 3 parcels owned by EverDomain has mobile homes on it. This particular sliver of this one parcel has not for 6 years because a tree fell on it, and they've been unable to gain acceptance from the city to replace it. Based upon the public comments, there's been numerous requests over the years to do that. And so my point, and the entire point of what we're trying to say is I think there's some legal and constitutional issues, all of which I talk about in my brief, but the main issue is this. The non-conforming use has not been discontinued. Because, what's the logical conclusion here, right? If a mobile home lot sits vacant, then just over time, the city can just pick off lots here and there. Oh, it's been 12 months and a day. Took too long for you to fix that up. I understand contractors are backlogged 2 years right now in most places in Columbia County, still responding to Hurricane Helene damage. They're only doing emergency repairs and then coming back for the final ones. My house, personally, was scheduled in 2026. I put a tarp over my roof until it can be fixed. I'm kind of fine with that. The insurance company's paying for them, give me a stipend, whatever, I'll take it. But, the point is, Grovetown can pick off lots one by one, and so you have a mobile home park that will go to 23 lots, 22, 21, 20 over time, as mobile homes get damaged and, obsolesce, basically. They depreciate out of existence. I don't think that's what that statute says. I don't think the non-conforming use has ceased. The non-conforming use was a mobile home park, and that's still on every single one of these parcels. And as you heard from the testimony, they've been advertising it, trying to get people in there. And so even if it's been vacant for more than 12 months, the discontinuance is being caused by circumstances outside the control of the property owner. Market forces, things they can't control. They're trying, every single one of them, to get people to put a mobile home on that lot and haven't been successful. So I don't know if that answers your question.
I have a question.
Yes, ma'am.
Have they applied to replace the mobile homes that are damaged already?
In the exhibits, there have been several applications, and this was all turned over by the city, but there were some people, the gentleman with the Hispanic name, I believe, applied in March because he had very significant damage, and that's that inspection report. I know when I showed that, your eyes kind of perked up a little bit. There's been people that have had damaged homes in the park that have applied. They've gotten permits to do repairs, things like that.
Have y'all applied? I thought I heard you say like 2 or 3 of them were severely damaged and will need replacing, correct? Has he applied to replace those yet?
Well, again, so the way the law works in that, the mobile homes themselves, the majority own, and I think the majority, if I may ask, do you own any mobile homes in the park? Yeah, yes.
So we do not, Everdomain Mobile Estate do not currently own any of the actual mobile homes in the park. The tenants owns 100% of them.
And that's what I thought. So the way mobile homes work, they're titled like vehicles.
I know.
You get a vehicle
Oh,
title.
very.
Yeah, okay. And I'm sorry, I don't mean to sound condescending.
No, not at all.
But if a mobile home is damaged, the mobile home owner is in a difficult situation because they still own lot rent, and they still have something sitting on the dirt, but it's the responsibility of the actual owner, the title holder of the mobile home, to try and fix it.
Well,
Have
didn't-
any of them applied? I'm just curious, are
Yeah.
they going to allow them to replace the ones that are damaged in the 1-year time frame? Or is this a one-time off because this lot has sat empty for 6 years?
So that's probably that's a fair question.
Yeah.
But why I stood was to point out to you that in Title 12 of the ordinance, there's a specific section that deals with maintenance and repairs. It's relevant for several reasons, but the documents that were provided, they asked for kind of a typical Open Records Act request in a matter like this. Give us all your blank regarding 213 Railroad Avenue, which is the address of the parcel that has all these lots on it. And many of those will show, none for parcel 13 or lot 12, but many of the lots have sought permits and made repairs. I believe in those documents, there is a request to replace a mobile home done within a year of the loss of the prior one. It's approved, and I presume they replaced it. I can't tell you they did. I just can tell you the permit was sought and granted according to
That's
the
right.
records.
Yeah. So they're
This is very precisely, and I can see where Mr. Peel's client maintains that if the mobile home park is used that way, regardless of abandoned lots, then no lot can lose its legal non-conforming status. That's not our position, and I'll address it when it's my turn. But
Absolutely.
the issue is this lot. And by the way, if you have a mobile home that got destroyed in the storm, and you apply to get another one, if you do it in a timely fashion, consistent with the state statute and this ordinance, there's not an issue. The issue is, does this ordinance protect Mr. Wang to be able to put a mobile home on a lot that's been vacant for years? That's the issue.
6, to be exact, 6 years. Yes,
That's-
I think it does.
okay. Lawyers, we pinpoint what the disagreement is, and we are presenting you all with the facts. You'll consider those facts, and by the way, if either side disagrees with whatever you decide, there can be an appeal, and the court won't disturb the facts that were presented here. There might be legal questions that, frankly, Mr. Peel and I won't know the answer to because this statute has never been tested
That's right.
at a higher court.
Because again, it was passed in July of 2023, so no cases on it.
Job, but we're gonna make our best arguments to you based on the facts,
Mm-hmm.
and you've gotta make a decision, and nobody's gonna judge you for your decision, because it's an interesting legal one.
Yes, it
But,
is.
I think factually, we're probably in complete agreement. I didn't know we would be, but Mr. Wang admitted what I
Yeah.
wanted him to acknowledge, and,
Yeah.
and so it's pretty clear. It's a vacant lot for years, whether or not somebody wanted to put a home on it or not, nobody did.
And I'll point this out, just to piggyback off it, there's a reason why we did the court reporter and all this. I mean, obviously, there might be an appeal, there might not be, I'm not gonna presume, but what I've seen with these, if we go up to another court, regardless, if the city appeals or if I appeal, that court says, you had your chance to give evidence before this board, that's it. That's the only thing we're gonna look at. There's not gonna be another trial, another hearing. This is the trial. So you all got to be our trial judges today. So I appreciate you giving me the 40 minutes you gave me to present it, but I think everything's in there.
And Mr. Wang has already purchased another mobile home.
He's purchased another mobile home, that's correct.
So he will own one, then, if he's purchased one.
That's, yeah, in this particular case, I mean, I can let him answer, but I think his plan is, what, is that wrong? Am I wrong? I don't want, we're here for the record.
Have you purchased another mobile home? That's the question, right?
Another mobile home or another mobile home park?
Another mobile home.
Okay, so we first submitted the permit application in which the city of Grovetown has denied, so we have stopped the purchase process. But we were negotiating with the seller in regards to the purchase of this mobile home, which was in the exhibit. That's the permit application for.
Mr. Wang, but how old was the mobile home? Was it, because there are times when it's referred to as a new mobile home, and other times when I've seen that it might not be a brand new one. Can you tell the board whether it's a, what year was manufactured or whatever?
Yeah, Mr. Scott. So the mobile home that we intended to put on there, I believe it's after the HUD code, HUD code, which is after 1976, if I'm not mistaken. And I believe there are years of the mobile home on that permit application. I couldn't really recall the exact year, like from the top of my head, but.
But it's a pre-owned mobile home, not a brand new one, correct?
Yeah, but we could also put a new one if that's a matter discussed here.
And what's the plan? If you own it, so are you going to rent it, or somebody else is going to purchase it from you, I guess?
Sorry. So if our permit application was approved by the city of Grovetown, we plan to move the home up to that vacant lot by a licensed installer, and also to sell it to interested and qualified tenants, so they become the owner of the home, and we just collect lot rent only.
I'm sorry, I've forgotten the attorney's names, but
That's all right.
a lot of times in the footnote of statutes, they have they have defined terms. Is discontinued use defined in one of the footnotes at all?
The city may disagree, but this is a statute that I don't believe has a definition section. Discontinued use is not defined. Now, I will say, discontinued use, I kind of alluded to it when I started, but these are all concepts that our courts in Georgia have been talking about for years and years and years. Vested rights, non-conforming uses, discontinued uses, things like that. The legal terminology that the courts have used in the past was abandonment, if it has been abandoned. One of the frustrating things about this statute is they did not use that word. They used discontinued use. So all the case law kind of explains what abandonment means, and then this statute uses the phrase discontinued use.
There's
So-
no case law for discontinued use.
Mr. Kelly will correct me if I'm wrong, but I don't think that there is a statute or a case that says this is what that word means, or that phrase, because it's two words, discontinued, means in this statute.
I'm
So-
happy to give you all a copy of the statute. It does have a definition section, defines manufactured
have
home to be consistent elsewhere in the code, defines mobile home to be consistent elsewhere in the code, but it does not define many of the words used in it, and that's because unless a word is defined prescriptively, like many words are in our ordinance, it is deemed to have its plain and ordinary meaning.
That's right.
If it's used in a specific context, like engineering or something like that, it will be construed to have the meaning in that particular context. And you're, of course, familiar with our ordinance. It defines a lot of terms. It tells us what non-conforming is. It tells us what a mobile home means in the ordinance. So, but just right about the fact that it does use that language. And there's a very specific provision. There are actually two in my mind, but the question is, that Jeff is focused on is, does the exception apply here so that his client can insist on another mobile home being put up there?
I think that's fair.
And I can discuss it a little bit, but I'd like to get my facts in, and they'll be brief, and then we'll move forward.
I'd still go with that. I'd go with yes.
All right.
Yep,
Yep.
that would be great.
And I'm not, y'all have I get it, it's a tough job, and it's tough for people with, formal legal training and all that. I'm just gonna call briefly, Mr. Palmer to come up here and speak into the microphone. I think you all know who he is, but I am gonna make the record clear. Can you state your name, please?
Jacques Palmer.
And you go by Jack, right?
That's correct.
Jacque for your first name?
Put an S on the end of it, and you got it.
Oh, yeah, the French spelling. I apologize. I know a lawyer with that name with no S. Okay. So what is your position with the city?
I am Director of Planning and Community Services
And how long have you been in that position?
since September 30th of 2024.
So right after the storm?
Correct.
Okay. And in the course of your work for the city, you work regularly, I presume, with the zoning ordinance that was adopted in May of 2023, correct?
Correct.
And at the time Mr. Wang acquired the lot, that zoning ordinance had been in effect for almost 2 years.
Correct.
The board already has a copy of the ordinance before it, as well as pre-existing ordinances. The ordinance in question, when it was adopted, it superseded all the preceding ordinances, correct?
Correct.
And that ordinance is available to the public to review at leisure here at the city, isn't it?
That is correct.
It's not kept from anyone.
No.
In the course of your job, did you have some communication with Mr. Wang about this piece of property? And we're just going to call it 213 Railroad Avenue. I think is it Railroad Drive?
Railroad Avenue.
Railroad
But
Avenue.
But that is correct.
In the city.
Correct.
And why did Mr. Wang reach out to you?
I was actually reached out by a real estate broker
Thank you.
and saying that he had a potential buyer that was interested in purchasing 213 Railroad Avenue
And did you, yeah, keep going, I'm sorry.
and asked, they had noticed that there was an empty lot or an empty pad in that park and asked if it was against the city code to bring another mobile home in there. And I researched the code and informed Mr. Tootin with the brokerage company that it was not in accordance with our zoning codes. The lot had been empty for more than a year, and the previous owner did not ask for an extension for that of the 12-year period. And so therefore, they would not be allowed to bring a mobile home onto that particular pad.
Now, you said 12-year, but you mean 12-month, correct?
12 month, I am
Right.
correct, sorry.
What was the zoning on 213 Railroad Avenue?
It's zoned RC1.
Are mobile homes permitted under the current ordinance on R-C1 property?
No,
What is the only district under the current zoning ordinance that allows mobile homes to be put on them for residential use?
that would be R-1,
And that's the only permitted use?
correct.
Okay. Now, I'm going to show you what I've already marked and given to Mr. Peel as City 1, and just ask is this, just in the interest of speed, I'll lead you a little bit, is this a copy of the email string beginning with Mr. Tootin, the broker, reaching out to you, and concluding with a February 13th email from Mr. Wang telling you that he disagrees with your decision about the lot being, a mobile home not being allowed to be put on Lot 12?
Yes, this is the email.
Okay. Let me just tender that.
No objection.
you've already heard testimony that in spite of you telling Mr. Wang that he could not put a mobile home on the lot, he purchased the property anyway. And then in, I guess it was June of this year, you received, or the department had communications from Mr. Wang on behalf of his company, Everdomain, Mobile Home Estate LLC, I'll just call them Everdomain. And they submitted an application to put a mobile home on Lot 12.
Correct.
Tell the board what happened.
We received the application in, as my duty calls for, I reviewed the application and determined that, again, that it was not in accordance with city code. It did not meet with RC1 zoning. Mobile homes are not allowed, and it was considered a legal non-conforming use. Then I went to the supplemental regulations, and that's where you find 6.070. It says that in essence, it says that if a lot is empty or a mobile home is removed from a lot and it stays empty for more than 12 months, then a mobile home will not be allowed to be placed on that lot.
Let me show you what we've marked as City 2. Is this the email chain, again, the complete one between your office, including you, and Mr. Wang, where you're responding ultimately in a denial of his permit request?
Yes, this is the email.
Let me tender this. And after you denied permit, I think the lawyers got involved, both Mr. Wang and his lawyer, and then, of course, I got involved, y'all reached out to me, and I got involved. Is that a fair summation of how things went from there?
Yes, but I would like to say I did state in that email that I gave Mr. Wang the opportunity to apply for a variance to appear before the Board of Zoning Appeals.
Did he apply for a variance?
He did not.
Okay. Do you know why not?
I have no idea.
Has he communicated with you at all about that?
No, he is not.
Did you hear from his lawyer at all about requesting a variance or pursuing other alternatives to the appeal?
No.
Okay. Now, you've addressed where in the letter the specific issue that you addressed about the fact that this lot had not had anything on it for years.
Correct.
And that was ultimately the key to your decision.
Correct.
But are there other provisions in the zoning ordinance that also present a problem for putting a mobile home on that lot? In other words, are you allowed under the ordinance to to replace a non-conforming use with another non-conforming use?
No, it's not allowed by the code.
Okay. And does the ordinance allow a property owner, even with a lawful non-conforming use, to expand that lawful non-conforming use later?
No.
The code, or the ordinance is in front of the board, so I may address some other issues later. But let me turn your attention to what we'll mark as City Exhibit 3 and then 4, just in the interest of speed. Would you tell the board, just to put it in the record, is number 3 a copy of the zoning map for the city?
Yes, this is a copy of the current zoning map.
And the print in the key is a little small. Let me hand you what's marked as City 4. Is that a blow-up of the section of the map that includes the area where this property is located?
Yes, this is,
I'm going to ask you to mark on there with this black marker, just circle it, the portion of the parcel at issue where Lot 12 is located. I'm going to give them another map in a second that'll help them even further. Okay, and you marked a little black dot on that.
Correct.
Tell you what, just put your initials right there on City 4, so we see the black mark of your initials next to the black dot. Perfectly. Move to admit 3 and 4. No objection. Thank And then I knew I had it somewhere. Let me show you what's marked as City 5. Is this a drawing that's showing the location on 213 Railroad Avenue of all the pads and the numbers associated with each pad?
Correct, it is.
And does that come from your office? Is that something you all had in your records?
That was in our records, and it was, my administrative assistant made me aware of this during the records research.
And I'm guessing from the label Marks Park, that was from the time when Mr. Coleman owned the property.
That is correct.
And this is, and it's already in the record, but Mr. Coleman acquired the property in the early 90s and then sold it in 2024 to Lockwood. That deed is in the record, so you'll have that. Move to admit number 5 in evidence.
I'm done.
And by the way, under 12, when this was put in the record, what does it say under 12?
Empty lot.
Okay, so when this was given to you all, it was already an empty lot.
Correct.
Okay. 10 to 5. And when Mr. Peel wrote his letter brief and his appeal that he's mentioned, is it fair to say you promptly handled that and forwarded the application, your response to the application, and Mr. Peel's letter to the board on June 30th of 2025?
That is correct.
And is this City 6, 7, 8, and 9, are these copies of all those documents, including your email forwarding this to the Board of Zoning Appeals? Is that them?
This is.
And there's some little redundancy here, board members, but I just want to show you that it was handled expeditiously, and I don't think there's any issue about it, but I'll move to admit 6, 7, 8, and 9.
No objection. I think all of these are already.
There's a little redundancy, I just want to make it clear and clean. And just for clarity, after you communicated with Mr. Wang last in June about the denial of his permit, you've had no further direct communications with him or his lawyer?
No, I have not.
Okay. All righty. No more for this witness. Jeff, do you have any questions for him?
Just very briefly. Turning to Exhibit 5, you said you saw this document in response to the open records request, or when did you discover this document, Exhibit 5?
During the open records request search.
Okay. And I notice it's not dated. Do you have no idea what the date of this?
I have no idea.
All right.
But let me further explain this. If this says empty lot, now I did research aerial records from Columbia County's GIS, and in 2021, that there was no mobile home on that lot in 2021.
That's right. And I think the testimony today from those who live in the park is that the lot's been empty for a period of 6 years.
Right.
And so you're not taking any sort of contrary position.
No, I'm just making the point that that had to have been done sometime after the tree fell on that mobile home.
That's all I have.
And I'll wrap up if it's acceptable to the board.
I have a question. Is that a, oh. We'll wait, okay, yeah, you finish.
I'll be happy to answer any questions, or I can talk to you for a second about the law. By the way, here is my copy off here's a copy of the.
Thank you.
I just want to ask about the dates. What was the state statute date and was the city ordinance date? When did they go into effect?
May I?
Yeah,
Because I don't have any of
definitely.
that.
If it
July
was passed in
1st,
23, it would have been likely July 1st.
And the city's was May of
July
2023?
1st. Yes, the city's ordinance, but as a practical matter, I'm not going to tell you you it doesn't matter, but I think Mr. Peel's argument is, I understand it, is that the state statute trumps the ordinance. And the question is on that is something I'm going to address now. The facts are in the record, and I've prepared a brief that I'm going to give to, a copy to the board. And, you know, when you prepare a brief before the facts are in the record, it's a little challenging. My facts section is pretty scant, but I'm delighted that the facts came in exactly as I expected they would, but with some more detail. Some of my questions may have seemed a little odd, like asking him about how much he paid for it. That's because one of the arguments, for example, that Mr. Peel made was that that he might sue the city for this was a taking of his property, what's called a regulatory taking. And I'll address that in the brief. I've addressed it, but that's actually kind of separate from the issues here because that's not a legal basis to challenge the decision. He's just saying that Mr. Wang might try to argue that this zoning is so unfair that he's had his property taken without due compensation. And because it's involving zoning, his lawyer made this regulatory taking argument. But his first argument, the one we want to focus on, is this statute that got adopted in 2023. And we're not going to be able to do it justice of the history in Georgia law where the courts deal with zoning, but I will just tell you, I think I can say this very comfortably, the courts loathe getting involved in zoning matters. And they do because this is something that's supposed to be done by local governments. But there are instances where they do get involved willingly, I might add, because constitutional issues are raised and things like that. So one of the issues that is brought to head is this statute 36-66-7. And the language of the ordinance really says, look, if you have a mobile home on your property, there are instances where you can't be deprived of putting a new one on there. But there are exceptions to that. And one of those huge exceptions are if it's removed and you don't replace it for a year, at least a year, we could say 2 years, but the minimum is a year. But if you go a year, like our ordinance says, and you don't replace it, that's a problem for you. Now, first of all, let me just say this. Mr. Peel argues for his client that the statute, it's subsection B of the statute, applies. I don't even think it does apply. And let me say why. The language in the statute requires the city, according to Everdoing, to put a new mobile home on Lot 12. But I don't think it applies because Lot 12 was vacant when they bought the property. He took it subject to the ordinance. And so the language of the ordinance is not regardless of when you acquire it. It is critical because it only applies to somebody, well, it says nothing is preventing. It only applies where it's preventing the continuance of the property owner's lawful nonconforming use. He was never prevented from a continuing nonconforming use as to Lot 12. Because when he bought it, it was not being used in a nonconforming way. Now, Mr. Peel's response to that is, well, no, you have to look at the whole property. You can't piecemeal lots out. But our ordinance, and the statute doesn't address this, our ordinance talks about individual mobile homes just as much as it talks about a single parcel with a single mobile home. I mean, our concern, the city's concern, when it passed the new zoning, was no more mobile home parks. That's very clear in the ordinance. It couldn't be clearer. And in fact, the first section of my brief doesn't even deal with the statute. That's the second section, because that's when I respond to Mr. Peel's arguments. But the first section of my brief talks about all the things in the ordinance that make it very clear why, as of actually long before 2023, Grovetown was saying no more mobile home parks. Now, true, the word we use in common parlance is there were old ones that were grandfathered in, and this is one of them. But I've made it, I think, fairly clear that that doesn't mean you get to step in, buy an old one, and start putting new mobile homes where they haven't been for years. There's only one lot here that was not that way. By the way, Mr. Wang wouldn't have brought this property if half of them were empty. Too big of a risk. This is one lot. And my question to him about the value was more about the takings issue that may not even matter to y'all. But because I don't think he can show that he had a total taking. That property still got a lot of value to him. And don't be fooled, he wouldn't have bought it if it didn't have a lot of value, regardless of Lot 12. So I will go through these, but focusing on the statute, I don't think it applies because, again, he didn't have a continuing nonconforming use when he bought it. There was nothing on that lot. The second thing is this. The exception, which Mr. Peel agrees, if this applies, this statute doesn't help him. And it says, the section B shall not apply where, under number 2, the nonconforming use has been discontinued for a period of time established by ordinance, which shall not be less than 12 months, unless such discontinuance is caused by circumstances outside the control of the property owner. They can't seriously be arguing that this was outside Mr. Wang's control. Because if that's the case, I mean, he didn't have it. If he could do that, then literally any time you run up against this ordinance, you could transfer your property to a shell company and they could say, well, I acquired it. I didn't have a chance to put the mobile home on there. That's not what the legislature meant when they adopted this. What they meant was, if they are adopting what Mr. Peel recognizes, and I recognize, is a long history of law saying if you abandon it, I don't care if they use the abandon word or not. Discontinued use is a soft pedal. But if you've abandoned that use for that lot, it's our position, you've lost it. And it wasn't just Mr. Wang who, I mean, he wants to put a mobile home there, but the prior owner, it's in the record, they owned the property from July of 24 until they sold it to him in April of 25. Nothing with Lot 12. And Mr. Coleman, I mean, how many years did he own the property? And I appreciate the commentary that he may have wanted to do it. All I can say is this, Mr. Wang showed us how easy it is if you really want to do it. You know, he bought the property, went out and was ready to close on a mobile home, and he was just going to rent it out or sell it or whatever. It wouldn't have been that hard. They abandoned it. And that's what happened here. And it's that simple. Now, he's made other arguments. I will tender this. I'm going to mark it, I guess, as an exhibit. Give me a second, and I'll find my exhibit label, but I'll mark it city. I guess we're on 9 or 10. So you all have it in the record and can look at it. But I will try to be bright. I talk too much sometimes, but we lawyers are all guilty of that. The subsections of the statute that I think are also relevant. By the way, our ordinance preserves the very things that the statute recognizes. By the way, if you look back at the ordinances we had before, they also have this same restriction. They don't always say 12 months. They usually just say a year. But you could abandon a legal nonconforming use under the old laws in Grovetown. This is not a new thing. And by the way, if you go from city to city and county to county, there's a lot of overlap because the people who draft these are not always lawyers. They're people who do this for a living. And they know about the law in this better than I do and better than Jeff does. I know better than I do, maybe not better than Jeff. But so things that are in the ordinance that are also relevant. We have the fact that we've already heard about where it's allowed, but in 6.070 that Mr. Palmer mentioned, it says, among other things, anyone seeking to locate a mobile home within the city must get a permit. It says the city will only grant permits for mobile homes for R1. It also says it has the 12-month prescription. If you abandon it, it's not, that's my word, but I'm summarizing it, for 12 months or longer, no new mobile home. And then, by the way, we also give an extension. If Mark Coleman had come to y'all and said, look, I need another 60 days, Jacques would have been bound to probably give him that 60 days. That's years ago. It never happened. So he lost that right. But Article 12 also has provisions that are directly relevant. And it directly applies to mobile homes. It has a very lengthy intent section, right at section 12.000. And you just need to read the end of it. In my brief, it's italicized. But it says, among other things, talks about the purpose of the ordinance, health, safety, welfare of the public. Then it says, and this is really important, a structure, building, or use which was established before the effective date of this ordinance and which does not conform to one or more of the requirements of this ordinance is a nonconformity. That's defined, by the way, in the statute. Such nonconformity may not be continued in perpetuity, may not be replaced, shall not be converted to any other use except a conforming use, shall not be expanded except as provided in this ordinance, and shall not be reestablished after discontinuance of operation for 1 year. And if that's not enough, section 12.010 has a great flat-out prescription, and that's in the repairs section. We want to protect people to be able to repair their property and take care of it, but what does it say? You read that list, it's very generous about letting people make repairs. The evidence submitted by Mr. Wang shows that. We've allowed people to make repairs, even replace them. But it says replacement of a non-conforming structure with another non-conforming structure is prohibited. And this is not a legal non-conforming use that we're dealing with now. We're talking about a place that has been, as the intent section says, discontinued. That is our position about those things. There are other arguments that they've made. They're saying that Mr. Wang has vested rights. He does not have vested rights. Vested rights would have been somebody who had the property, was using it as a mobile home park, and then the ordinance gets enacted. Yeah, he can continue to operate that mobile home park. Another example of vested rights, there are 4 specific situations that can arise for vested rights. That's where you're protected, you're grandfathered almost. You may not even have to be grandfathered. By the way, if Jacques' letters to Mr. Wang had said to him, oh yeah, you can build this mobile home, even if Jacques was wrong, he could have acquired a vested right. But that's not what happened. Jacques told him months before he bought the property, 2 months before he bought the property, you cannot do this. The vested rights situations, I've neglected to number the pages on my brief. That was really bright. But it lists them, and that's in section C of my brief in the argument section. There are 4 instances. If you were issued a building permit, didn't happen. The law in number 2, if the law in existence at the time the loan owner properly filed an application allowed him, well, that didn't happen. Number 3, formally and informally approved development plans, that didn't happen. And last, official assurances that a building permit will probably issue. None of those things happened. He could not, based on the evidence before you, as a matter of law, acquired a vested right to do that in those circumstances. But, so Mr. Peel and I agree about one thing, certainly, and that is you're going to have to look at this statute and see if it controls. I don't think it does. I think there are 2 reasons it doesn't. I've explained those, and I'm not even sure which one is the better argument of the 2. I think they're both accurate. If I'm not right, then what Georgia General Assembly has done, if I'm not correct about this, then what the Georgia General Assembly has done is no city or county in Georgia can move away from any non-conforming use if it's a mobile home park. And I don't think that's what they intended. I think they're trying to protect vested rights, people who are grandfathered. And that's my candid view on it. I appreciate Mr. Wang has moved in and is such a good landlord for his tenants, but that doesn't mean he can retake up a lot on this property that
has been vacant for years. That's our position. Nope, anything further? Sorry, evidence, yeah. Sorry? No, I've already tendered it, but I got to mark it. So I'm going to mark the brief as Exhibit 9 or 10, whichever it is. What was my last one? So that'll be 10, and I'll give it to you. No objection to it?
No
Yeah.
objection.
And that's just to mirror his letter brief.
Ladies, any comments? Questions?
And I'll answer any questions.
Yep. We have a job to do.
Okay. Anyone would like to make a motion to approve or deny the request?
Madam Chairwoman, I do need to make a point of order. You need to close the hearing first.
Okay,
Go ahead and,
I'll close the hearing.
okay. Now, I need to read to you out of the Board of Zoning Appeals bylaws and rules for procedures. In particular, subsection H, decision. After the public hearing is closed, the hearing body may either vote upon the application or may delay its vote to subsequent meeting, provided that notice of the time, date, and location of when such application will be further considered shall be announced at the meeting during which the public hearing is held.
Does that mean we can talk in private?
As of right now, you can move to executive session, and we'll provide you the room back here if you all want to discuss amongst
Yes.
yourselves, or,
Would like to move to executive session.
Second.
okay.
Do we have to make a motion?
Yeah, she just.
Okay.
Yes.
Five and six? Exhibits 5 and 6? What are you looking for? Oh, yeah. It's just 2 pages.
We're back in regular session. Anyone would like to make a motion to approve or deny request?
I'll make a motion to deny the request.
Second?
Second. We do an official vote? I did.
Vote.
She voted against it?
I'll turn it on again for you.
Do you disagree with the denial?
Red, it's got to go to green.
No, it doesn't have to. It's still 3-1. She's voting red.
Oh, she's voting red.
Yes.
I'm sorry.
Yes.
We have denied the appeal to place the manufactured home on Lot 12 at 213 Railroad Avenue. Anyone want to make a motion to adjourn?
Motion to adjourn?
I'll second it.
Let's call this meeting adjourned.